If you're in trucking, I'm sure you're probably aware of the AB5 Law. This is a big, huge thing that's going on right now. The AB5 Law currently affects California only, but it's very likely that if it's passed in California, it will go on to affect other states as well. And when I say pass, let me back up and make sure we understand something. The AB5 is already a law. What I mean when I say pass, I mean within the trucking industry, if it applies to trucking the same way it does to other industries, then trucking will be affected by the AB5 law. That would mean that a trucking company would no longer be able to hire the services of another company that's doing the same exact work that they're doing. For example, another owner-operator who's moving freight just like a trucking company would move freight. They would no longer be able to operate as an independent contractor. They would have to have employee status. That, of course, changes the game in a major way. Take, for example, someone like Landstar. Landstar has a lot of independent contractors. Well, you would no longer be allowed to be leased on as a trucking company, as a driver to that company. They would have to call you an employee in order to utilize your services. Now, of course, the entire business models will have to be changed of companies like Landstar if this takes place. Now, currently there's an injunction in place that stops AB5 from entering the trucking space right now, but that could end any day. And when it does end, it's very possible that they could start applying AB5 and saying that if you are an owner-operator, you cannot be leased on to another trucking company. That could very well happen. Now, what would you do in that instance if you're basically operating under that way of doing business? How would that change what you're currently doing? What would you have to do in order to get things structured so that you could continue working? So I think there's a lot of questions that has to be answered, and you hope that they wouldn't go in and just automatically start applying something like that and then make the trucking industry adjust. Hopefully there'll be a time period where, you would be able to get your ducks in order before the institution of that law. Now, how do we end up here? How do we end up with an AB5 law? Why was there a need to protect employees? Well, there's a company called Dynamex. It's a parcel delivery company, and it changed the status of employees that it had to independent contractors. And of course, when it did that, it took away the employee benefits that come with being an employee. So Dynamex would eventually find itself in court for changing the status of some of these employees to independent contractors. And this is how the Supreme Court of California ruled. It said that it defined the definition of independent contractor in California should follow the ABC test. And I am going to cover the B prong of that because that deals with what we're talking about today. It says the B prong holds that a worker can be viewed as an independent contractor if the worker performs work that is outside the usual course of hiring or of the hiring entity's business. A trucking company hiring an independent owner-operator to move freight risk running afoul of this provision. So that basically means that if you're doing something outside the scope of business that particular business does, then you can be seen as an independent contractor. But if you're doing the same job that you would do or they would do on a daily basis, performing the same task, then you cannot be seen as an independent contractor. You have to be seen as an employee. So in essence, what they're doing is forcing companies not to take advantage of status, employee status, or independent contractor status, I should say, and assigning everybody independent contractor status so that you don't have to pay employee benefits. Now, as you might already know, this is not going to go down. This AB5 law is not going to go down and be applied to the trucking industry without a tremendous battle. You can just assume that companies like Landstar, huge companies who have these type business models, are not just going to lay down and say, oh, okay, we accept that, because that would ruin everything it is that they do. They would have to change everything about what it is that they do almost. So they're not going to just say, oh, okay, we're cool with that. They have lobbyists that I'm sure are fighting this right now. As you already know, as I said earlier, there's an injunction in place, and that injunction could last up to 2023, or it could end tomorrow or Monday. So we'll see how that goes. but just expect that this will be a long, drawn-out battle. And this is not very likely to come to a conclusion very soon. But it just makes sense. It passes a common sense test that if you currently operate in this manner, for example, if you are owner-operator and you leased on to another company, then it's probably a good idea to start looking at what would you do if you didn't have the ability to lease on to another company. I think as business owners, we often talk about government overreach and the government putting their hands into things that they should not be in. But when you have companies that try and take advantage of certain statuses, for example, in this case, the independent contractor status and assigning independent contractor status to employees to simply benefit themselves when it really boils down to it, and to hurt the employee. When you have that take place, you have to have intervention. And when we say it's overreach, but it's necessary sometimes. In this case, with this particular company, and if it went down like it has been described, to me, that is a problem. That's a big problem, and we have to have laws to make sure that employees are protected. Now, it will be interesting to see who this law is actually applied to, because I wonder in my mind, will it be applied to freight brokers? From how I see it, it probably shouldn't be applied to freight brokers, because it says in that B provision that I'd read you earlier that if you are providing the same services. Well, there's a difference in brokering services and actually moving freight. So I think there's a difference there. But what if you are an asset-based carrier? You could be performing some of the same duties. So will you be able to have relationships with carriers through your brokerage? I don't know how that would work. Very interesting to see how this thing will pan out, who it actually applies to. So that's what I wanted to share with you today. I would certainly like to know what you think. Leave us a comment in the comment section and let us know your thoughts. If you're interested in learning more about the freight broker business, I'll leave a free link in the description. It's my 5-video series, and I titled it How the Load Movement Process Works. It will give you a chance to come into the office with me and watch me via video as I move loads, talk to shippers and carriers to give you a better understanding of how the business works before you come into it. And then if you're interested in learning what the costs are, what are the costs associated with owning your own freight broker business, about how much it's going to cost you to get started, I'll leave a free video right here. So until the next time, I wish you the very best in your life and business. See you at the top, because the bottom is much too crowded.